transactions leading to the sale of 7 oil mining leases. And while that is going on, the House of Representatives concentrates on the investigation of illegal transfer of oil blocks. The Nigerian Bar Association is deeply concerned about the killing of innocent citizens in Baga, BORNO State. The association frowned on the confrontation between men of the Joint Task Force and militants in Baga, describing the aftermath of the clash as shocking. The NBA president, Mr. Okewale, said that even though Nigeria is going through tough security challenges, it is not enough reason for the security agencies to turn their weapons on innocent citizens. But somebody is also concerned about the security situation in the country. That is the former presidential candidate, Professor Pat Utomi, who says the constant criticisms that continue to trail the government's efforts at handling the security challenges in the country will only worsen the situation. These are the words of Professor Pat Utomi. He told Channels Television that Nigerians and indeed security analysts need to take a cue from the international community, which he said seemed to be more interested in helping Nigeria find a lasting solution. And on the foreign scene, the special prosecutor in former Pakistani Prime Minister Benazir Bhutto's murder case has been shot dead. According to reports from Islamabad, Chaudhry Ali was seriously injured by attackers on a motorcycle in the capital and died in hospital from his injuries. At least one person was also killed in the shooting. The police investigation is currently underway. Those are the headlines. Back to you, Chamberlain.
All right, and thank you, Nata. Well, we're getting back to looking at judicial reforms in the judiciary. And, of course, you know, some actions were going down recently, and some also anticipated in the days to come. We're joined now by Onyekachi Bani, who is the chairman of Nigerian Bar Association, Ikeja branch. Morning, and thank you for coming on today.
Thank you, Chamberlain. Good morning.
Well, yes, we did get a brief commentary from you about Justice Talbot's matter, but looking at it holistically now, I mean, it's supposed to be a part of a complex whole, which the judiciary should take to reform itself such that that confidence can always be there on the part of the people. But looking at some of the recent actions, not just from the CJN, particularly from the CJN, those decisions, you think that some steps are being taken, or perhaps these steps are more or less like the tip of the iceberg?
Well, the position is that Nigerians are encouraged by what is going on in the judiciary at this point in time, especially with the recent punishment meted out to some of the hearing judges.
Is that sufficient to
issue of sufficiency is another matter, but the point is that they have started. Somebody, occupied that position before, probably the men, and they were not courageous enough to take some punitive actions against some of the hearing judges, and somebody is now occupying that position, happens to be a woman, and the woman is very courageous enough to, say, look, let's restore confidence because we are lawyers and we have litigants that patronize the courts. And the moment they lose confidence in the judiciary, then anarchy will set in. People will begin to take laws into their hands and then refuse to approach the court. And so justice must not only be done, but must be seen to be done. And not only the lawyers to see that justice being done, but even the ordinary man that patronizes the court. So issue of confidence is very key. It's a critical arm of government that creates a balance in the system. And the moment that confidence is lost, then there is a problem. When she came in, she made that promise. Look, that she had discovered that judiciary has a problem, the issue of corruption, the issue of funny judgment at times, the issue of controversial rulings of some of the judges is very disheartening and not encouraging Nigerians to have confidence in judiciary. I said she made a promise before the Senate that she will go about reforming the judiciary. Within the 2 years, she's going to be there as the CJN. And she started in earnest. And we're seeing certain things happening in that particular arm of government that shows that, look, there is still hope for this particular nation. So it may not be too sufficient, but the point is that she has started, and another person should be able to build on what she has actually started as a foundation.
Well, if you look at some of these actions that were taken, there are those who argue that we can't really say that we're starting anything to engender or stir up that confidence on the part of the public if we don't go about changing the way judges are appointed.
I agree with you. The issue of appointment is critical. Who is appointed into that arm of government? We've said it here that It's a very grave responsibility for you to be a judge. You occupy what we call temple of justice, and that temple must not be polluted at any point in time. Whosoever comes here must not contaminate it. You must be intellectually sound. You must have the issue of integrity, character. Those are key, and then it must be purely on merit, not on who recommends you, or you come from the governor's recommendation or that of the minister. No, but purely on merit. And taking people who are actually practicing the law itself, who have traversed the length and breadth of this nation, who are very conversant with the procedures of law, and then make them to be judges of both High Court and that of the Federal High Court and Court of Appeal. And don't bring people based on issue of quota. At the moment we introduce quota in this nation, of course, you know where we are as a nation today. So the point is that arm of government must be filled purely on merit. And so appointment is very key. If we don't get it right in issue of appointing judges, then I can assure you that it may remain the way it is, presently. Issue of corruption, issue of incompetent judges, issue of controversial rulings, issue of order that make mockery of judiciary will continue. So it is very key. I agree with you that appointment must be looked into.
I was just about to say that you heard the argument of your colleagues concerning the decision of the NJC on Justice Talba. A host of them have said that, well, that was just the NJC playing to the gallery. Others have said that, well, if it wasn't them playing to the gallery, then that particular decision wasn't sufficient. Do you agree with them?
Well, issue of playing to the gallery, I don't agree that they play to the gallery. You remember, if you know the NJC composition, when it comes to issue of punishment of judges, usually it's the judges themselves that sit and punish. Other lawyers who are members of the NJC will be excused from the chambers. They don't sit in punishment of a judge. Though some people criticize this also, how can you expect judges to punish themselves? But they have done it under this present CJN. It started with Achibong, the other judge from Plateau, and now we have Justice Okeke being one for the first time. Also, this other man that has been suspended for a year.
Why do you think that they weren't playing to the gallery?
They were not. The point is that, what did they say? Why did they punish Justice Talba? He exercised a discretion, and the NJC is saying that discretion was exercised wrongly. He must exercise discretion judicially and judiciously. There are ends of justice, and if you look at theories of punishment and sentencing, one of the main reasons why people are punished for crime is to ensure that they show remorse and show repentance, and then be made to face the consequences of the action. That is one. The other one is that it deters. If somebody is punished for committing a crime, the other person that who is a potential criminal will be deterred. So look at the consequences of committing a crime. Now, if in your sentencing, if in your pronouncement, it shows you are even encouraging the commission of crime, or those who want to be criminals should go ahead, at the end of the day you are going to give them a pat at the back and all that, then you have not succeeded in really bringing out the theory behind sentencing, and you have done evil to the society, because a judge sits in the temple of justice to make pronouncement in order to ensure that the stability created, both morally, structurally and legally in a country, so that people will follow the law and do the law, that nobody should be above the law. Now, if you make that pronouncement and at the end people now see it as something that is a mockery of justice, then there is a problem. So they say that the man exercised his discretion wrongly. Now, the law under which he was charged gave a maximum punishment of 2 years or an option of fine. Now, there was the issue of plea bargain. If you follow that particular story very carefully, there was the issue of plea bargain that came in. The prosecutor had to drop all the charges and now reduce it to only one, which had a punishment of 2 years and an option of fine. Now, there was an agreement. The plea bargain came into the entire thing. The prosecutor reached an agreement with the defense, and then before the judge comes in, because the judge has a role to play, look, we have agreed, we have reduced the charge from so amount to this. Now you're going to punish him, but there must be a custodial sentencing. That was agreed. And then when the judge now made a pronouncement, he now exercised discretion by giving an option of fine, different from what was agreed. And I'm sure this information was brought before the NJC. They heard all that. They must have also called the prosecutor to come and give evidence in this matter. Remember when they suspended Mr. Charles and Justice Charles Achibong? They said that, look, they're investigating Justice Talba, and they want to get his own side of the entire story, and other people that are involved in the entire thing. I must have gotten the full facts that there was an agreement that this man must be sentenced to 2 years imprisonment or whatever. But they didn't do that. He didn't do that. He now gave an option of fine. Give an impression That you can go ahead in this country and commit a crime.
Was that within the purview of the NJC? That's the question now. Was that within the purview of the NJC?
What was within the purview?
What if just done to Justice Tom?